as regulators, the Federal Communications Commission has the task of trying to figure out how do we maintain a vibrant marketplace? How do we make sure that companies can be profitable and protect the public interest? And it's very clear that as this amazing digital transition occurs, that you as regulators can sort of have your cake and eat it too. Comcast is already an extraordinarily profitable company. It does not need NBC Universal to be even more profitable. It will be more profitable, but it doesn't need it to survive. So the question is, in many ways, this merger is as simple as saying, does one company need to go from being really profitable to being astronomically profitable, or are we going to check their power and allow 1,000 blossoms to bloom and allow all these new innovative upstarts to come in and be profitable too?
What is must-have programming, and what content should we really be focused on when identifying and looking at the issues in this merger? And I'll start with you, Mr. Blum.
Imagine a scenario where Comcast decides they're going to be the exclusive providers of Universal Studio movies online, and the license agreements that we have today to provide Universal Studio movies on pay-per-view and video on demand terminate, and we no longer have those rights. Imagine a Dish Network customer who had those movies and can't get them any longer, and that the only way they would be able to get E.T. And Schindler's List online would be to subscribe to TV Everywhere or become a Comcast cable subscriber. And certainly, I think in the Hispanic market, Telemundo, the RSN in Philly, it's the aggregation of all of that content that gives them an enormous power to misuse it.
People need to have access to the kind of content that's being debated within this merger. But there is this larger issue of journalism in the Fourth Estate in this country, which really, by all accounts, is in crisis. I mean, we're seeing newspapers with the divorce of advertising revenue and news content. They're falling off a cliff right now. They are the dominant provider of critical journalism in most communities in this country. And we have to look through a journalism lens as well when we look at this Comcast-NBC merger. The reality is that when companies consolidate in the manner that we're looking at here with Comcast-NBC, profit pressures are bigger than any I could possibly describe sitting here right now. They are so huge that the merged entities have a well-documented history, and we have every reason to believe Comcast will follow the same path if this deal happens. They lay off journalists because it's expensive. They cut investigative journalism, the kind that might have actually dug into that problem with the blowout preventer on that oil rig in the Gulf of Mexico, or might have dug up some intel on what was happening with our housing market and the financial industry before it blew up in 2008. We already have a well-documented trend of major corporations cutting newsroom staff and really compromising the Fourth Estate. And in its place, we have cheap-to-produce shows like Comcast's Hurl show about people vomiting. We have people eating worms on beaches. The quality of media is going down as these companies make rational decisions to cut costs and boost profits. The fact is news is hard-hitting and it's controversial, and it angers people in power. And we saw that with Watergate. We saw that when McClatchy did good investigating on weapons of mass destruction leading up to the Iraq War. And companies like a merged Comcast-NBC, they want to stay away from that. They and their advertisers, that doesn't help the bottom line. So it's really critical that for the purposes of promoting a vibrant and critical Fourth Estate, that this deal be looked at through that lens.
A number of you have expressed the concern that Comcast as a broadband provider might discriminate against independent online content in its delivery of that content. The Commission, as you know, is exploring that risk with respect to all broadband providers in a proceeding on net neutrality. In what respect does this merger make Comcast unique in that respect? Is there some increase in Comcast's ability or incentive to discriminate that would make it appropriate for us to address this net neutrality issue in connection with this merger, or should we address it as part of a rulemaking proceeding for the whole industry?
You should do both. I think the incentives for discrimination are greater here. Comcast has to protect their 25% market share. Their revenue from the cable subscription is enormous. And I think it's with the acquisition of this content, whether you call it must-have or critical content, gives them the incentive and ability to really misuse that content by discriminating on their pipe. And I also think the Commission has the ability to impose real conditions to protect the open internet that I think hopefully will set the groundwork for what the Commission, we hope, will do in the open internet proceeding.
Yeah, the Commission should certainly do both, but there's ample opportunity in the merger to say the addition of NBC content gives Comcast more of a reason to discriminate online, to avoid these nascent online video distribution providers. And the risk for the Commission in the wider proceeding is that the definition of managed services comes to encompass exactly what Comcast wants to do here, which is to provide a TV everywhere-like product. So I think it would be incumbent on the Commission to use the merger as an opportunity to grapple with what managed services and reasonable network management mean in the context where the stakes are being raised by the addition of NBCU content.
Yeah, I agree with both of those statements. This is the first merger of this size that's occurred when the technology now exists in a widely deployable form to allow a broadband internet service provider to manipulate users' internet experience, to monitor what they're looking at on the internet, to delay or to interfere with those connections, to favor their own content or affiliated content in ways that really weren't feasible in some of the previous mergers. So the technology exists, the financial incentive to engage in that kind of discriminatory conduct exists. We have here in this case an example of a company, the first company that's ever been held by the FCC to have violated some basic tenets of openness rules relating to what not to do in terms of blocking internet content. And so those rules are extremely important, and they ought to be applied to the merger. I think one of the big ticket items in the net neutrality rules that would be very helpful is the requirement that Comcast display some transparency about how it manages its network. If it is increasing its so-called managed services and favoring its proprietary linear programming and providing more bandwidth into the pipe for those kind of programs and making the open internet smaller, the best efforts internet smaller, what that does is it has an impact where consumers' ability to access content from Amazon.com or iTunes to stream those videos live might be impaired, or they may have to pay more for that through increased bandwidth charges, where it would be less expensive for the consumers just to use Comcast's own video on demand services or their competing products. They would also be certainly incentivized to discriminate against online content that is that competes with Comcast proprietary content. So there are many financial incentives for Comcast to behave badly here, and these network neutrality rules, I think, are extremely important to ensure that the public, one, knows what's happening in the network, but two, can be assured that their choices about what kind of content they're viewing aren't artificially manipulated by the broadband provider.
I often feel like I'm the translator for this very wonky area of work we're in. And just to be clear, net neutrality being this basic idea that's existed for the 40 years that the internet has existed, that all content more or less moves at the same speed. My video is going to upload to the web at the same time, at the same speed as ABC's. With that in mind, our concern is, frankly, about the mechanics of policymaking and the fact that in 2010, in Washington, D.C., the sheer influence of the telecommunications lobby, in this case the Comcast, Verizon, AT&T, their lobby is so incredibly powerful. They're the second largest, biggest spending lobby in this country, second only to Big Pharma, Big Health, that it's so formidable that these ideas that Susan referred to, like managed services or reasonable network management, these are sort of catchwords for big hunks of cheese to put big Swiss kind of holes through that you can figure out ways to manipulate content in order to make more money. And that is both the butchering of an analogy, but also a really a critical warning for the Commission that we need a very clear, solid net neutrality rule that doesn't have a bunch of ways for folks to get around it. It's very simple.
As most of you know, Comcast has proposed a number of conditions, and I think most of them have limits or expire after a certain amount of years. Because things are changing so rapidly and there is such innovation in the space, what do you think about these conditions and kind of the limited period for which they exist, or the proposals exist?
This is another tough area for the Commission. Program carriage needs to be overhauled. Program access needs to be overhauled. The Department of Justice needs to be brought in to make sure that these rules are enforceable and that they apply online as well as in the cable context. It's a tremendous task, and I don't want to undersell it. But the commitments that Comcast is making so far don't go to these deep structural problems with the market that the merger raises for all of us. That we have the nation's largest broadband provider, the largest cable company, merging with this enormous content provider. Just as in the '92 Act, Congress tried to set up a set of rules that would constrain the ability of these actors to extract monopoly rents from consumers, this is another one of those moments. But it's going to take very simple enforceable rules that the Department of Justice comes in on. Because we've seen with the '92 structure how easy it is to evade it with bundling and pricing and just complication that these companies can get around. So that's your task.
As I said in my testimony, the problems of this deal are baked into the very structure of the new company. And frankly, the only way that you'd have conditions that were sufficient to protect the public interest would be so stringent and permanent that the deal would probably be no longer appealing to Comcast.